Good afternoon.
Good afternoon.
How are you?
Fine, thanks. And how are you?
I am fine.
Good.
I didn't hear anybody else, but I would like to start the class just by going around to see how long you have been in banking. That gives me a good idea as to how we should approach the course. So,
Okay.
Ellen, since you're on,
Yes,
how long have you been in banking?
just 3 years.
What do you mean just? That's plenty.
Just plenty? Okay, 3 years.
Yes, okay. All right. Capron?
Good evening. 5+ years. I've lost
Okay.
count.
You lost count? Oh, Lord. Taylor.
Evening. A year and 2 months.
Okay. Now that's someone who's just started. Russell?
Good evening. 4
Good.
going on 5 years.
Okay. That's not bad. Who's next? Decius? I pronounced that right? Sydney?
Yes, ma'am. Good evening.
Good
5
evening.
years going on 6 years.
Okay.
Good night.
Good night. Nadia, how long have you been in banking?
I've been in the bank, working in the bank.
Yeah. Mm-hmm.
5 years.
Okay. All right. So on average, everybody's roughly around the same. Roma?
Currently going on 2 years this December.
Oh, okay. All right. So you're kind of new.
Yes, ma'am.
Not okay. All right. And most of you in what area? Customer service?
Yes.
Teller? Okay.
Yeah.
All right.
I'm in back office.
Oh, Nadia?
Yes, ma'am.
Okay.
And I'm in collections.
Who's saying collections? Ellen?
Yes.
Okay.
This is Russell. I am currently training in loans.
Ah, okay. All right. Okay, yeah, because you've been there for a while. You and Strawn started 3 years, so she's moving on. Sydney, you're in where? Which section you're in?
Pardon me?
Which department you in?
Customer service.
Okay, all right then. All right. So the first class, some students complain that it's like too much if I go into chapter 2. So for the first class, what we do is we look at an overview of the legislation that governs banking law in the Bahamas. So that's where we begin. So I know you probably would have picked up your manuals. I don't know if you had a chance to read the first chapter. Anybody did?
Miss Acha, I didn't have a chance. I'm in Abaco. I'm correction Freeport. So I have to wait till they send my book.
Okay, all right, that's fine, that's fine. Anybody else had a chance to read it? No?
Not as yet, no, ma'am.
Okay, all right, okay.
Glance.
Glance, okay. So I think attached to your manual would have also been a copy of the Banks and Trust Companies Regulations Act 2020. So you should also be receiving that. So when we talk about banking law in the Bahamas, there's certain laws that you should be familiar with. And those laws will govern all of the aspects of banking law. But there are also things that we do in banking that is a part of common law. And common law means statute law that comes from different sources. And we'll cover that next week in the second class. But for this class now, we're going to look at the law in the Bahamas that governs banking. And the very first law that governs banking in the Bahamas is the Central Bank of the Bahamas, because you can't have a supervisory authority that doesn't have a body that governs what it does. So that's the first thing, is you have the Central Bank of the Bahamas Act itself. Now, when you look at the Central Bank of the Bahamas Act, what it does is it establishes the framework that there is a governor, there is a deputy governor, and it speaks about the aspects of the various departments that govern banking in the Bahamas. It speaks also about exchange control and the purpose of exchange control. Has anyone read the old version of the Central Bank Act? Anyone?
Oh, ma'am. I
Oh
never
my
even read
God,
the
no,
Central
no.
Bank Act.
Hold on now. For the new person, I expect to hear that. No. Over 3 years, you should have at least looked at it. No?
No, ma'am.
Oh my Lord. Okay. Let me see how I should bring this in. Okay, so the act itself talks about banking business, and it more or less gives you the function of the central bank. So everybody knows where the central bank is located, correct? And they know that they're in the process of moving to a new premises. So just overall, the central bank just governs the financial system in the Bahamas. And it also is a part of dealing with governance and money supply for the Bahamas. Now, the act that really pertains to banking itself and to what you do every day is the Banks and Trust Companies Regulations Act 2020. And that act actually defines what is banking business. So for banking and being a banker, you should know what is the definition of banking business. And that has changed over time. So the act states that banking business means the business of accepting deposits of money, which may be withdrawn or repaid on demand, or after a fixed period or after notice, and employing those deposits in whole or in part by lending or otherwise investing them for the account and at the risk of the person accepting them. What do you think that means? What is banking business? By law. In layman's terms, what does that mean? For a bank to say that it's doing banking business, what should a bank be doing? What should that company that has a banking license be doing?
My call.
What called?
because this is how you tell whether an institution is actually doing banking business. It has to fit within the definition. So Sydney, what would you say is banking business? What would make a company that opens its door as offering services to the public? How would you say that they are doing banking business? What are the activities that should be done in that institution to say that it is a bank?
Well, I'd say more so retail banking in terms of like deposit into accounts, opening accounts, term deposits, and loans and withdrawals, like day-to-day transactions.
Mm-hmm. And by looking at the definition, it says also lending.
Lending, right?
And investing.
Your mic on, eh?
And it says at the risk of the person accepting them. And then it says banking business also includes money transmission services. And the word banker is to be construed accordingly, which means that if you're offering that service and you work within that institution, then you are a banker. So you'll see when we go further down and we begin to talk about the banker-customer relationship, because Sydney, that's what you do, that when we begin to talk about that banker-customer relationship, you will see that we will begin by starting from common law. Because everything you see here that is in the law came from common law, which means it came from cases that were tried in the United Kingdom. As a Commonwealth nation, we follow that law. But over time, we have legislated our own bank and trust companies regulations. And you will also learn when we go further down that the definition of banking business changes also over time, and it depends on the community in which you operate. So in order to be a bank, you have to have a company. And a company has to be incorporated under the Companies Act. An IBC cannot be licensed as a bank. A director is a member of the board. And of course, you know that the governor is the person who's in charge of all of the financial institutions. And the regulatory function means those are the activities that are carried out by the central bank itself. So a controller. Controller means a person in accordance with whose direction, instructions, or wishes the directors or officers of a licensee or of another company of which the licensee is a subsidiary are a customer under an obligation, whether formal or informal. And so here what the act is doing is defining who is in control of the banking institution, who exercises significant influence over the management of the banking institution, or who is holding the shares of the banking institution. And that's where the act then defines who is a controller. Now we define what is banking business. The act then gives you a definition of what is a deposit. So whenever you're having if there is a matter that comes before the court and you want to know whether or not the funds are a deposit, then the act actually tells you what is a deposit. And so in your own words, what is a deposit?
Funds
Anybody.
placed on your funds held by the bank on your behalf.
Okay. Now if you have your book, look and see what it says. What is the definition in the act itself? How's it define deposit?
I don't have the book, but
You don't have the book
in
yet.
the regulation,
Okay, go ahead. So tell me, what does it say?
it's the unpaid balance of money or its equivalent received or held by an institution from or on behalf of a person in the usual course of business and for which the institution has given or it is obliged to give credit to that person's checking, savings, demand or time account, or for which the institution has issued a certificate, receipt, check, money order, draft, or other instrument in respect of which it is primarily liable.
Mm-hmm.
And such other payments of the bank may by regulation prescribe, excluding subject to subparagraph 3, any unpaid balance of money or its equivalent received or held in relations to the provisions of property other than currency or services or giving of security. And for the purpose of this act, an unpaid balance of money or its equivalents is referable to the provisions of property or services or the giving of security.
Mm-hmm. Only if it is paid by way of advance or part payment under contract for the sale, hire, or other provision of property or services, or it is paid by way of security. So the act itself defines for you what is a deposit. And that is the definition that you go by when you're operating an account. The inspector, and you all should know who's the inspector. Who's the inspectors of banks and trusts and money service business and credit unions? Anybody knows who's the inspector? Nobody knows? No clue? Her name is Karen Roll. She replaced Mr. Charles Luttrell. So she has that responsibility to make sure that the banks and trust companies and money service businesses and credit unions and private trust companies are operating within the guidance and the laws of the Bahamas.
Okay.
Karen Roll, Miss Karen Roll. A licensee, all that means is that is a company that has been licensed by the Central Bank of the Bahamas, by the Bank Supervision Department to carry on banking business or trust business or money service business. And that licensee can be a standalone entity, or it can be a branch, or it can be a subsidiary. And remember, in law, a branch and the parent are one. In a subsidiary, if an entity is subsidiary, it has its own board. So it is a separate entity, even though it is a part of a group. So under Section 4 of the Act, it is prohibited for anybody to use the word bank in their name or trust company unless they're in possession of a valid license. And so anyone who's carrying on business that would be defined as banking business according to the legislation requires a license from the central bank. Now, in order for you to be considered for an application to carry on banking business, Section 6, says anyone who wants to carry on banking business from within the Bahamas has to make an application. And that application has to be in writing and contain the information that is required. And if you go on the central bank's website, it gives you an guidance for application to apply for a license. And in order to apply for a banking license, you must have the nature and sufficiency of the financial resources, just not the resources to start the business, but the resources to continue the business. You have to have a business plan that is feasible and sound. And whatever activity you're carrying on, it has to be in the best interest of the Bahamas' financial system. It also has to be in the best interest of the public. And of course, the central bank will advise the minister of their decision, whether or not they're going to grant the license or not. Now, during the process of whether or not a person will be granted a license, the central bank makes a determination as to whether those persons are fit and proper. And those persons who are fit and proper are all the persons who are the shareholders, the persons who are members of the board, and the persons who will be functioning as senior managers. They all have to be vetted as being fit and proper. And again, on the central bank's website, you will see there is a document called the confidential statement. And on that statement, these persons who have to be deemed fit and proper have to state where they have worked before, what positions they have worked in, whether or not they have been arrested before, whether or not they have served jail time before. I think, and whether or not there's any breaches that they want to report to the regulator. So it's always best for them to come out and state exactly what they have done, rather than waiting for the central bank to advise that they found out that there are things that they did not include in their confidential statement. So Section 10 sets out the condition for the granting of a license. And 11 and 12, sections 11 and 12 speak to the application and the registration of money transmission business. 13 and 14 speak to registered representatives. Those are private trust companies. Now, part 3 deals with ownership of licensees, in particular, transfer of other disposition of shares, approval and objection of controllers, and gives the bank the power to make direction if a person does not meet the requirement of being fit and proper. Part 4 speaks about the duties and the obligations of licensees. And remember, licensee means bank or trust company or money transmission business or credit union or private trust company. So part 4, again, under section 20, speaks to the requirement to publish statements of accounts. So unless the central bank has given a licensee an exemption, they are required to publish their statement of accounts. And I know you have seen banks publishing their statement of accounts in the newspapers, which is done annually.
Yeah.
Okay, so I know you've seen that. And that's a requirement by law. So sections 21 and 22 speaks to the requirement of the licensee to notify the bank of the appointment of an auditor, and also to state the power and the obligations of the auditor. They're also required to notify the bank of any material information, and they're also required by law, as it states here, to furnish any information that is requested by the central bank. Part 5 speaks about the supervision of licensees and registrants. So this is where the bank supervision department comes in. And I know you all heard about the bank supervision department. when they would come and do their on-site examinations. So sections 27 and 28 establishes the office of the inspector, and it also sets out the duties of the inspector. Section 29 states the sanctions that may be imposed on a licensee or registrant, which includes the revocation of the license, the amendment, variation, imposition of conditions to the license, the substitution, the variation, or imposition of conditions to the license, the substitutions or removal of a director or officer, appoint a person to report on the proper conduct of the licensee's affairs, or to report on the bank, or to appoint a receiver, or appoint a statutory administrator, or issue direction. So the central bank, when a bank is not acting in the best interest of the public at large, or if it is not in compliance with regulations, or if it is not in compliance with its own policies and procedures, it can actually institute any one of these sanctions on a licensee. And especially if they're acting in an unsafe and unsound manner, which means that the banking that they're practicing doesn't follow the law. And of course, a bank can decide to surrender its license if it's ceasing to do banking business or trust business. And then, of course, a bank can decide to go into liquidation. And that's what will follow the winding up process. Sections 32 to 34 speaks about foreign supervisory authority, because you know that when a bank has a parent abroad, they normally would ask for information from the local subsidiary so that all of the information can be consolidated. And then, of course, part 7 addresses miscellaneous matters and deals with prohibition orders. And the most important section that you have to remember, and as a part of everything that you do in banking, is section 77. Anyone who has it in front of them want to read section 77? Because that's one you should know by heart as a banker. Section 77 of the Banks and Trust Companies Regulations Act 2020. What does it say?
77, let's see if I find it. That's the preservation of confidentiality.
Yes. That's one that you have to know. Now we're going to come back to the same section 77.
Excuse me, Ms. Arthur.
Yes.
I just want to know what page exactly we're on.
Oh, in the book?
Yes, ma'am.
Oh. My page is on number. We're in chapter 1.
Chapter 1, okay. All right, thank you.
Under Banks and Trust Companies Regulations Act.
Okay.
And we're just about to the end of that.
Okay, all right then.
Yeah, but it says part 7.
Okay.
Okay. So section 77, preservation of confidentiality. What does it say? 2 persons can read it because it's very long. Or 3. Let's go. Get started.
No person who has acquired information in his capacity as a director, officer, employee, or agent of any licensee or former licensee, FA, be counsel and attorney, consultant, or auditor of the bank, or as an employee or agent of such counsel and attorney, consultant, or auditor. C, counsel and attorney, consultant, auditor, accountant, receiver or liquidator of any licensee or former licensee, or as an employee or agent of such counsel and attorney, consultant, auditor, accountant, receiver, or liquidator. D, auditor of any customer of any licensee or former licensee, or as an employee or agent of such auditor. E, the inspector under the provisions of this act. F, a supervisory authority or as a director, officer, employee, or agent of a supervisory authority shall, without the express or implied consent of the customer concerned, disclose to any person any such information relating to the identity, assets, liabilities, transactions, or accounts of a customer of a licensee, or relating to any application by any person under the provision of this act, as the case may be, except 1, for the purpose of the performance of his duties or the exercise of his function under this act, if any. 2, for the purpose of the performance of his duties within the scope of his employment. 3, when a licensee is lawfully required to make disclosure by any court of competent jurisdiction within the Bahamas or under the provisions of any law of the Bahamas.
Yeah,
4, for the provision of
the
any
computer in room
assistant
4 by
bank
CA.
to exercise
okay.
any functions
Yeah, I
conferred
see it. Okay, everybody on.
the bank by any written law.
Ellen, Lanika, okay, okay, bye.
Continue?
Yeah, that wasn't me. That was Miss Dean.
Okay.
Yeah.
5, in the case of a bridge institution, to the minister of his designate. 6, in the case of an asset management vehicle, to the minister of his designate. 7, to a person who has a view of the institution of, or for the purpose of, A, criminal proceeding, B, disciplinary proceedings, whether within or outside the Bahamas, relating to the exercise by a counsel and attorneys, auditor, accountant, valuer, or actuary of his professional duties, or C, disciplinary proceedings relating to the discharge by a public officer or member or employee of the bank of his duties.
Okay, so stop right there. Since you read it, now let's get someone else to answer the question. What is it saying? What is your duty as a banker when it comes to confidentiality? All of that you read just now as a banker, because it says that no person who has acquired information in his capacity as a director, officer, employee, or agent of any licensee or former licensee. So you would fall into the category of being an employee. What does the law say? What is your duty? Anybody? What is your duty when it comes to confidentiality? Come on. We have some 5-year-olds in there. Let's go. And some 3 years old. What is your duty of confidentiality? Everybody's silent. Not one. Go ahead.
I'll give it a try. Can you ask the question again for me, please?
Okay, so I'm saying, as the law says that the preservation of confidentiality, the same section 77 covers you as an employee, an agent of the bank. It covers an officer of the bank. It covers a director. It also covers your attorneys, any consultant, any auditor. What does that mean? What is this duty of confidentiality?
From a bank perspective, what is a duty of confidentiality?
You as an employee, what is that duty?
Just ensuring that each customer information is private. ensuring that you don't disclose any customer information of any sort.
Okay. And it says, when can you disclose?
I would say you would be able to disclose from a legal perspective based on legal representation. So either the customer can request the information, or it has to be documented from I would say a legal perspective.
Okay. You have the act in front of you?
You could disclose court of law.
Earlier, I was still trying to
Court of
find
law,
that.
okay.
You could disclose in a court of law, or if I'm discussing it with the customer, or on behalf of the customer with their consent,
Yes.
or to another agency where it requires it is my job under the act.
So we're gonna discuss this duty of confidentiality in another class. But what we're doing here is just introducing you to the law. And when we discuss this preservation of confidentiality, because earlier it was called a duty of confidentiality, and we will take the same confidentiality and we will learn that from common law, which is case law, and we'll bring it back to our legislation. And what do we have in law? Now, subsection 2 says that subsection 1, all that was just read, does not apply in situations where the information from such class or classes as the inspector may from time to time approve. That means that when a supervisory head office asks for information on a local branch or subsidiary, they have to get the permission from the inspector. So information that is transmitted from a licensee here in the Bahamas, and it goes either to the head office or to a branch or to a subsidiary outside of the Bahamas, that is permitted. But it has to be solely for the purpose of carrying out collation, synthesis, or processing of information on behalf of the licensee. So that means that the client's names do not go to the head office. All that will go would be the type of account and the balances. So it says now, in any civil proceedings where information is likely to be disclosed in relation to a customer's bank account, those proceedings may, if the court of its own motion or on the application of a party to the proceeding so orders, be held in camera, and the information shall be confidential as between the court and the parties thereto. So if there is a civil matter, then the information can be relayed, but it's actually not done in an open court. It says in subsection 4, no person shall publish the name, address, or photograph of any parties to those civil proceedings referred to a few minutes ago in subsection 3, or any information likely to lead to the identification of the parties thereto, either during the currency of the proceedings or after they have been terminated. And the bank may, subject to the provisions of section 32, subsection 2, provide information on the beneficial owners, directors, officers, and operations of a licensee. So you know that once you have a bank and trust license, you know that the central bank has the authority to provide to another party requesting information on the beneficial owners of its licensees, and who are the directors, the officers, and who is actually the senior officials running that bank. To facilitate regulatory cooperation, this is subsection 6. The governor or any director, officer, employee, agent, or advisor of the bank may cooperate with any other domestic regulatory authority. So this subsection 6 gives the domestic regulatory bodies the authority to exchange information. And the exchange of information on beneficial owners, on directors and officers. So anybody who is coming into the Bahamas to act in any one of those capacity, when the central bank is carrying out its fit and proper exercise, it will communicate with the other regulatory bodies, who in turn will go out to their partners and find out whether or not those persons have worked before and whether or not there is anything that is untoward in their character or in the way in which they carried out their duties in past jobs. So then it says in subsection 7 that nothing contained in this section shall prejudice or derogate from the rights and duties subsisting at common law between the licensee and his customer. And that's going to be the focus as we go through the manual. We're going to talk about that common law between the licensee and his customer. And that common law means case law. And so that means that as we go through the various units in the manual, you're going to see that there are lots of case law. Some of the cases you will not have to know for the exam, but for some of them you will have to know, because those will be the typical ones that you should know as a part of banking law.
Excuse me, Ms. Archer.
Yes.
Are you reading from the banking law student workbook? Because I'm honestly trying to follow, but I am really having a hard time finding anything that you're reading.
With your manual, you should have received the Banks and Trust Companies Regulations Act. If you didn't, it is online.
Okay.
Yes. So I'm reading from the Act itself. The Act is 113 pages. So we're reading section 77, which is found on page 77 of the Act. In subsection 10, it tells you that if you contravene section 77, which is the preservation of confidentiality, that you will be guilty of an offense and it shall be liable on summary conviction to a fine not exceeding $25,000 or 2 years imprisonment or to both. So we'll come back to the duty of confidentiality and we'll take it from the common law perspective, as it was mentioned in subsection 7A, and we will then look at that in comparison to what our law says in terms of preservation of confidentiality. Now, in the same part of the legislation, it speaks to treatment of dormant accounts. That's section 78. Anyone in class familiar with dormant accounts? Or deal with dormant accounts? Or request for dormant accounts? That's section 78, page 80 of the Act. Anybody deals with requests for dormant accounts? Yes, no?
No, I don't, I never dealt with
Sydney, he said he does customer.
We don't really have much cases of them, but that's mainly when I'd say an account has been in the inactive stage for more than 7 years.
Yes.
And those funds usually are transmitted. If it has a balance, it's usually transmitted over to central bank.
Mm-hmm.
And in cases where the customer were maybe to come back to the bank to query, that they'd actually have to reach out to a central bank to find out the status of those funds.
You gotta fill out the form, eh?
Right.
Yeah, fill out the form. Okay, so in the new act, it tells you that Section 78, which speaks to treatment of dormant accounts held by banks, applies to a deposit account, which includes a demand account, a savings account, and a fixed term deposit account. B, a checking account. C, a bank draft, a cashier check, a certified check, and money order. D, a traveler's check. E, a credit balance on a credit card. F, a credit balance on a loan. G, collateral held on a loan, including cash and non-cash collateral. H, funds paid for shares or other interests in a licensee. I, a custody account or safety deposit box. J, a deposit account of precious metals and precious gemstones. K, all securities that are listed in Part 1 of the first schedule to the Securities Industry Act. And L, such other deposit account or other facility as the bank may, by notice, determine. So what the central bank has done now in this new piece of legislation is that it has expanded the coverage under what is dormant account. So then it defines who is the customer. So a customer is defined as a person who holds an account or other facility, a person who, in respect of an account or other facility, is authorized in writing to act as the agent of the person who holds the account or other facility, or a person who is authorized under a power of attorney to manage or control an account or other facility, or where a person who holds an account or other facility is deceased, the heirs, executive administrators, and assigns of that person, and such other person as the bank may by notice determine. So you see, under dormant account, they have expanded the definition of customer. If we go back to the very beginning, when the act spoke to definitions, the word customer is not defined in subsection 2. A customer is defined in section 78 as it relates to dormant accounts. Because see what it says in subsection 2, for the purposes of this section. So a customer, when we begin the chapter on the banker-customer relationship, that definition of customer is not the same as the customer definition under section 78 of dormant account treatment. So the act says a customer is anyone who holds an account or any other facility with the bank. But a customer can also be a person who is authorized in writing to act as an agent of the person who actually has an account at the bank. And later down, we're going to discuss who is an agent. So we're going to come back to that word agent. Then it says here, a customer is the person who's authorized under a power of attorney. And we're going to come back also to that phrase, power of attorney. And it says a customer is where a person who holds an account or other facility is deceased, and it tells you that there is executives, administrators, and assigns of that person. Do you know what that means? Subsection 2, D. Do you know what that means? Where it says a customer is where a person who holds an account or other facility is deceased, the heirs, executors, administrators, and assigns of that person. Anyone knows what that means?
So that is like if somebody dies and they have a will, or somebody goes to the process of a probate, that person would then become our customers if they're the executor of that person's estate or the administrator of that person's estate.
Correct. And then it says such other person as the bank may by notice determine. So what really is a dormant account? A dormant account means a deposit account or other facility at a bank where the customer has initiated no transaction for a period of 7 years. With respect to the deposit account or other facility, any other deposit account or facility of the customer held with the bank. And then other facility means any account or arrangement that is provided by a bank to a customer, by, through, or with which a customer may conduct transactions, including bank drafts, manager's checks, money orders, and traveler's checks. Precious gemstone does not include jewelry. Then it tells you about the recognized foreign securities exchange and registered securities exchange, and then transaction. So a transaction means an action initiated by a customer in person or by electronic or other non-physical means in respect of a deposit account or other facility that such customer has with the bank. And it includes a deposit, a withdrawal, exchange or transfer of funds in any currency denomination, whether in cash, by check, payment order, or other instrument, a communication, acknowledgement, request, or instruction where evidence in writing and signed by the customer, a contemporaneous record of the customer's verbal instruction prepared by the bank. The 7-year period referred to in the definition of dormant account in subsection 2 shall be calculated in the case of a deposit account made for a fixed period from the date on which the fixed period terminated or the date the customer terminates his instructions to automatically renew the deposit, whichever is the later. A deposit account not made for a fixed period from the date on which the customer last conducted a transaction with respect to the deposit account. And a facility other than the two referred to earlier from the date on which the facility was issued, established, or the obligation to make a payment in respect of the facility accrued, whichever is the later. A bank in the Bahamas shall, where liability exists by reason of a dormant account held at such bank, within 2 months after the end of the calendar year in which the applicable 7-year period expired, pay to the bank an amount equal to and in the same currency denomination as the amount owing by the bank in respect of the dormant account. And that's including cash from a dormant safety deposit box. So you see the time period, right? Within 2 months after the end of the calendar year, after the 7-year period has expired, then that bank has to send those funds to the central bank. So subject to subsection 10, liquidate a dormant account, including a safety deposit box containing precious metals, precious gemstones, or securities, and after deducting the reasonable costs incurred in connection with the liquidation of the account, pay the balance of the proceeds of sale of such account to the bank, provided that the bank may exempt a bank in writing from this subsection where extenuating circumstances exist. I leave out the section with the securities. So, subject to subsection 12, no person shall have a claim for any act done pursuant to paragraph B of subsection 4 against a bank, a registrar and transfer agent, or any other person acting for or on behalf of the bank. A bank shall retain for a period of 15 years after the day the bank makes a payment to the central bank pursuant to subsection 4, or for a period of 5 years after the bank makes a payment to a claimant. All records relating to the dormant account in respect of such payment was made, including the register, the signature cards, the signing authorities, microfilm, or electronically stored copies of such records. So notwithstanding subsection 8, the relevant period for the retention of records where a bank makes a payment pursuant to subsection 4 or subsection 12 with respect to the securities account shall be 17 years and 7 years respectively. Let me see without. So under section 15, it says a bank shall maintain a register of dormant accounts containing, in respect of each account, the full name and the last known address of each customer, the last known telephone number and contact of each customer, the name of the bank and location of the branch at which the dormant account is held, account number, the type of facility, the full description of the assets, including the currency, the fee status, indicating whether the account was subject to any fees immediately prior to the transfer to the bank and the amount of such fees, the interest status, indicating whether the account was subject to any interest earned immediately prior to the transfer to the central bank, the date of the last transaction on the account, the measures that were taken to contact the customer, and the case of funds in transfer, the filed copy of the instrument or transfer, the date funds were paid to the central bank, and any other information that the bank may in writing require a bank to maintain in the register. So you see, the central bank has widened the scope of dormant accounts and how they should be treated. And also, they've extended the retention period for documentation. Now, I didn't add in the note section 79, but section 79 speaks to charges for accounts to be by agreement. So as you all are bankers, you know that whenever the bank is changing their fees by law, they are required to advise. So section 79 says charges for accounts to be by agreement. No bank shall directly or indirectly charge or receive any sum of money for the establishment, the maintenance of service of an account unless such charge is made by express or specific agreement between the bank and the customer. And that word, that agreement, is fundamental to banking law. Because as you will see, as we go through the units, that banker-customer relationship is built on an agreement. And you will see as we move further into the manuals that agreement is based on contract law. And contract law undergirds banking law. So you're going to have to learn a little bit about contract law to understand banking law. Any questions so far? Any questions on the Banks and Trust Companies Regulations Act? No? Silence means yes, everything is okay?
No question.
Okay, so the next one. Sydney, I know you got at this one. Deposit Insurance Act. What is that about? What's the maximum deposit that's insured by the DIC? Anyone knows? What's the maximum amount that is insured? Or put another way, what is the coverage on the deposit insurance? Huh? Yes, I
good?
heard it.
Oh, I'm just checking on you. Oh, okay.
Anyone knows?
Yes, I calling y'all now, so I ain't gotta call up.
Anyone knows? No? So the maximum deposit amount insured by the DIC is $50,000 per depositor. And of course, that amount can be increased by the minister. So let's just say you do have an account with a bank. Does that include your interest? Does the $50,000 include your interest or just the deposit on the account? And answer to that is yes. The deposit insurance includes both principal and interest. And does the deposit insurance cover other currencies? Anybody?
And no, it does not.
Okay. So what if you have a joint account? How does it work?
I think with joint accounts, it depends on how it was set up
Okay.
in terms of like tenants in common or any design.
Mm-hmm. So if we are co-owners, that means we're gonna hold it equally. How is that covered under the DIC? So if a husband and wife are co-owners of a savings account and each own a savings account, the joint account and each of their savings account are separately insured up to the maximum of the $50,000. And the same thing if you have a person who has an interest in more than one joint account. The DIC does it the same way. It aggregates all of the amount that belongs to that one person. And the order where the names are on the joint accounts doesn't matter. So what if you have a savings account? Let's say your savings account is, the savings account's balance is $60,000. So you know that you should be insured under the DIC because the maximum is 50. But if you have a loan for 20,000, what happens? How much is the DIC insuring you for?
50,000.
If you have a balance of 60 and you have a loan of 20, how much are they insuring you for? You said 60?
50. 50?
50? No. They're
Maybe
gonna take they take the loan away from the deposit balance. So they insure you for 40. What if you have a loan and the institution closes, do you have to pay that balance?
Repeat the question, please.
If you have a loan and that financial institution closes, do you have to pay the balance?
No.
Whoa. Really? Oh, yes, you do. Oh, yes, you do. You've signed a contract, you know, and you have an obligation. You have to pay it. So let's just say a bank is in trouble. Or no, let's put it another way. What if you have 100,000 in the bank? So you know that only 50,000 can be insured. What happens to the next 50,000 if that bank is in trouble? Anybody knows? Let's think of your money is in the bank. Your balance is 100,000. Let's just say you have a loan balance of 10, so that's 90. What happens after the DIC pays off the 50,000? What happens to the 40,000? How do you get your 40,000? If you get it at all?
You'd have to go to the central bank.
Why you go into the central bank? Come on, explain it to me. Why you go in there? Why you think the central bank has your $40,000? You have 100,000. You have a loan balance of 10,000. The DIC only covers you for 50,000. So how or what, if you can, how will you get the other 40,000? Anybody knows?
I go right back to the same company.
You mean to the same bank?
Yes.
Yeah, in a way. So what happens is that you will get a certificate that says that the institution owes you 40,000. And that certificate is presented to the liquidator. And then of course the liquidator would prorate that, depends on what he realizes from the sale of the assets. Or what he realizes from the amount that he's going to receive from the creditors. So it has to go through the liquidation process. So remember that.
Okay. Is that something like the CLECO situation?
Yes.
Okay.
Mm-hmm. Yeah, so that's how the deposit insurance works. And I know we don't hear a lot about it because we haven't had any banks since Gulf Union. Now, we're gonna do a whole chapter on money laundering. But I know you all know the legislation that governs money laundering. You know, you have the Proceeds of Crime Act, you have the Financial Transaction Reporting Act and its regulations. Those are the three main pieces of legislation.
Repeat that again.
The Proceeds of Crime Act,
Mhm.
the Financial Transaction Reporting Act, the Financial Transaction Reporting Regulations.
Okay.
Add to that, the Anti-Terrorism Act. So when we do the chapter on money laundering, we'll discuss them in more detail. But the Financial Transaction Reporting Act, what it actually does is it gives the financial institutions the guidance in terms of conducting risk assessment and doing customer due diligence. What's even more important is maintaining records. So the same way how the treatment of dormant accounts spoke to maintaining records, when it comes to a client conducting transactions, the Financial Transaction Reporting Act speaks to the retention of records. It also speaks about having proper controls in place and knowing suspicious transactions. So the Financial Transaction Reporting Act has its own definition of who is a customer. And it also defines what is a facility and who is a facility holder. So it says a customer is a person for whom a transaction or account is arranged, opened, or undertaken. A signatory to a transaction account is also a customer. A person to whom an account or rights or obligations under a transaction have been assigned or transferred. It could be a person who is authorized to conduct a transaction or control on an account. It could be a person who attempts to take any of the actions referred to in A to D, which means it can be someone with a power of attorney or someone who's acting as an agent. Or it says any such other person as prescribed by the minister, because the minister has the authority to amend or change the definitions. And then it's defined funds as any assets or property of any kind, however acquired, including but not limited to currency, bank credits, deposits, and other financial resources. Traveler's checks, bank checks, money orders, promissory notes, shares, non-shareholding interests, securities, bonds, drafts, and letters of credit. And we'll come back to negotiable instruments in some of the units near to the end. Then it speaks to what we call identified risk. And identified risk are the risk that we here in the Bahamas have looked at in every sector and determined these are some of the risks in our jurisdiction. And so the identified risks are corruption, cybercrime, human trafficking, money laundering, proliferation of weapons of proliferation or financing of weapons of mass destruction, terrorism or the financing of terrorism, and any other risk as the minister may prescribe by regulations. So that means that whenever the Bahamas decides to conduct a risk assessment of itself, it can identify other risks. Then the act defines who is a PEP. And we'll go through that when we do the chapter on money laundering. And it also includes virtual currency. So the regulation speaks to more of how things work. And it gives you the designated accounts and the limits for transactions, which is $15,000. For gaming houses, it's $3,000. For jurors, again, it's $15,000. And the regulations require you to verify the identity of a person requesting to be a facility holder. So if a financial institution has reasonable grounds to suspect that a person is conducting a transaction on behalf of any other person, the financial institution must verify the identity of that person. And of course, you know the MLRO is obligated to report suspicious transactions. Any questions there? Because we're gonna do a whole chapter on that.
Just want to confirm, we still on the act or we in book?
No, we're in the book now. You're talking about 3 different pieces of legislation. You're talking about the ones that is the legislative framework for money laundering.
And this will be page 9.
And I was telling you, my own doesn't have any numbers on it.
Okay.
Yeah, you should see it. It should say the Financial Transaction Reporting Act, the Financial Transaction Reporting Regulations.
So
But added to
we in
that
the
would be
act-
the, go ahead.
we in the act or regulation now?
You and your manual.
Oh, no, I have no manual. Okay,
No, you don't have your manual. Did they send it to you electronically?
no,
They should have.
Hi, Ms. Archer. I have a question.
Go ahead.
I just want to confirm, because I hear you saying manual, the banking law student workbook, is that what we're following, or it's supposed to be
Yes.
something separate?
No, that same document.
Because the only thing I see is the Financial Transactions Reporting Act 2000. I don't see the transaction reporting regulations.
Yes, it's right after it.
I'm not sure. I don't know if anybody else having the same problem as me, but
It's not there. The only
Yeah.
thing that's after the Financial Transaction Reporting Act is key definitions and obligations to verify identity.
Okay, I have to check it. But it should be there because mine has it. I'll double check. Then I'll have them resend it because they send it electronically, right?
No, ma'am, it's the actual book. It's probably a
Oh.
different version.
Hold on.
yeah, this is the banking law book that we would have gotten from the office. I didn't receive anything electronically.
Okay, so you have the Financial Transaction Reporting Act and you have the key definitions, correct?
Correct. Yes, ma'am.
Okay, so what's your question now?
Because you were
Because
saying
after-
we're supposed to be following with the financial transactions reporting regulations.
That's right
Right.
after it. That should be right after it. I have it on mine. You don't have it on your copy?
No, ma'am.
I need to find out why, because it's on mine. Because I'm reading from what I sent. Okay, I'll have to check it. I'll check and see why. Unless when they printed, they missed this page. So there are 3 pieces of legislation, like I said earlier, that governs money laundering. The Proceeds of Crime Act, the Financial Transaction Reporting Act, and the Financial Transaction Reporting Regulations. Added to that would be the Anti-Terrorism Act, which deals with proliferation of weapons of mass destruction and the financing of those weapons. But we'll come to a chapter on that. Have any of you ever read it? The Financial Transaction Reporting Act and Regulations, especially the regulations?
No, ma'am.
Okay. Would you want me to send it to you?
Yes.
Yes, that'd be fine.
Whatever you have, you can send it to us, please.
Yes,
Okay,
ma'am. You
just-
can send it to us, please.
I think that would be handy because it's something that you should know as a banker. no matter which department you go into, you know, you normally have the annual training. The annual training is normally focused on what you do and whether there have been any changes in the law. But as a banker, you should know what's in the Financial Transaction Reporting Act and the regulations. Because if you don't know it, then in terms of making a report that you feel something is suspicious, what are you basing it on? So you have to know the law. You don't have to memorize it, but if you've read it, then you should know exactly what looks suspicious to you. And we'll come to that later. And then we have the Anti-Terrorism Act. But that is a little bit different from the Financial Transaction Reporting Act, because what you're looking at is whether or not the transaction itself leads you to a suspicion that it is going to be used to fund terrorism. And there are methods of how that is done. So the Act speaks about biological warfare. It speaks about chemical weapons and how funds move and how terrorists act, terrorist organization. Who is a terrorist organization and terrorist property? Now, whenever we speak about confidentiality, connected to that is the Data Protection Act. And the Data Protection Act again speaks about the privacy of individuals' information. But the Data Protection Act is more geared towards the collector of information. That's the data controller. So the Data Protection Act is geared towards the bank itself. And it's saying that they have a duty to keep that information in the bank confidential. And there are some sensitive personal data, such as a person's race, their political opinions or their religion, the physical or mental health, their sexual life, all those things are confidential. So the bank itself has to protect the privacy of individuals when it comes to them collecting a person's data. So the bank has to, when it collects the information, they have to use it for the purpose for which they collected it. The data should always be accurate and up to date. When you collect data from your customer, it's kept for a specific purpose. And the length of time for keeping that data, it depends on the retention period for that data. And whenever you're collecting information on your client, that information should not be excessive. And of course, the data should not be disclosed in a manner that is inconsistent to the purpose for which it was kept. And of course, you can keep data longer than is required by law, unless you're using it for some historical or research purpose. And your data should also be kept securely from unauthorized access, alteration, disclosure, destruction, or accidental loss. So the Act goes through all the various sections in talking about prohibiting persons from having access to your client's data. The Act under Section 10 also affords an individual the right to prohibit the processing of personal data for the purposes of direct marketing. And of course, a data subject can sue the bank for the breach of their statutory duty of care. And we're going to talk about the statutory duty of care further down in the course. And just like under the preservation of confidentiality, under data protection, there are some exemptions to this protection. And one is when it's in the interest of the national security, if there are criminal investigations or prosecutions for taxes, or if it's for protection of international relations, if there is a civil matter to dealing with injury or damage or loss to a person or property, and any disclosure that's required by law. So similar to the preservation of confidentiality, there are some exceptions to this duty to make sure that the data controller keeps the subject's information current and accurate and is not accessible by everyone. Now, whenever you speak about data protection, which ties into Section 77 of the Banks and Trust Companies Regulations Act, we have also legislated offenses for the misuse of computers. Because you know, we've now moved into the technology era. And the Act sets out 6 offenses under the Computer Misuse Act. First offense is unauthorized access to computer material. That means that any person who deliberately intends to access information or programs held in the computer with the knowledge that that access is unauthorized, then they are liable to a fine of $5,000 or 6 months imprisonment for the first time. If you're found guilty on the second time, then it's double. And this is really referring to hackers. The second offense is access with the intent to commit or facilitate the commission of an offense. And this is committed by any person who uses a computer to gain access to any program or data held in another computer with intent to commit an offense. And the fine here again is a term of 2 or more years imprisonment. And if found guilty, the fine is $10,000 or 3 years imprisonment or both. The third one is unauthorized modification of computer material. So any person who deliberately or knowingly causes the unauthorized modification of the contents of any computer is guilty. The penalty is a fine of $10,000 or 1 year imprisonment. The subsequent conviction of the same offense is double. And if there is any damage caused, a person is convicted for that offense and they are liable for a fine of $20,000 or 3 months in prison. The fourth one is an unauthorized use or interception of computer services. And that means that any person who directly or indirectly accesses any computer service or intercepts or causes to be intercepted without authority, directly or indirectly, any function of a computer there is a fine of $10,000 or 3 years in prison or both. And for subsequent conviction, a fine of $20,000 or 3 years in prison or both. And then there is a maximum fine of $50,000 or 5 years in prison or both. The fifth one is unauthorized obstruction of the use of a computer. And this is if someone without authority or lawful excuse interferes with, interrupts, or obstructs the lawful use or functioning of a computer, or impedes, prevents access to any computer or data stored in a computer, then they are liable to a fine of $10,000 or 3 years in prison. And for subsequent offenses, $20,000 or 5 years in prison. And the last offense under the Computer Misuse Act is unauthorized disclosure of access codes. And this one is more related to you. It says that if you disclose any password, access code, or any other means of gaining access to any programs or data held in a computer for wrongful gain or unlawful purpose, or disclosing such information knowing that it will cause wrongful loss to any person, you're guilty of an offense. And the fine is $10,000 or 3 years in prison. And on a subsequent conviction, the fine is $20,000 or 5 years imprisonment. The act also provides for more severe penalties in instances where an offense under the act involves a protected computer, like those under law enforcement, public utilities, medical services. And the penalty for unauthorized disclosure of access code for those is $100,000 or 20 years imprisonment or both. The act also gave the police the power to search and seize, inclusive of access to information on computers under certain specified conditions. And the court have the power to order forfeiture of any property which was in possession or under the control of a person convicted on an offense under the act. Any questions so far? No? Another, go ahead.
No, I say no, ma'am, straightforward.
Oh, okay. So another piece of legislation that governs banking is the Payment Systems Act. Anyone familiar with that?
Never heard of it.
Oh, Lord.
Hmm.
No? Nobody? No one did tailoring? Someone must have been a teller in their former life.
What was the question?
The Payment Systems Act. Are you familiar with that?
No, ma'am.
Oh, Lord. Never heard of it.
No, ma'am.
No, ma'am.
I mean, we may know what the Payment System Act is, but the term itself, no, we never heard of the term itself, so we wouldn't know if the definition applies.
Okay, so tell me what the term itself means.
That's what I'm saying. We wouldn't know what the act entailed because we never heard this is an act. All of us been tell us before, but to say what the act is, we don't know.
But it sounds like another one I need to send you all then.
Please.
That's how it sounds.
Being recorded. Everything, please.
say everything. Okay, so the Payment System Act, that gives the central bank the authority to monitor the national payment system. So what that actually does is it gives the central bank the authority to design a public a policy to facilitate the stability of the financial system. So if you recall, or if you don't recall, or you may have heard, in the past, the clearing banks would all come to the central bank with their sacks of checks to be exchanged. Anyone remember that or heard of it? No? You heard about it, right?
That's one.
Okay. So this act speaks to the central bank now with the commercial banks, moving all of this in an automated system. So it says that the central bank, in pursuance of the policy objectives, it would facilitate the interaction of its clearing and settlement systems and related arrangements with other systems or arrangements connected with the exchange, clearing, or settlement of payments. So even in the afternoons, commercial banks send their messengers to the central bank banking department to do afternoon settlements. So that's when they would borrow money amongst themselves. Or if one bank had a check that would have come through their system and that check was for a large amount, then they would come to the central bank to settle that amount of money. All of that is now done electronically. And that's what this legislation is about. So what it did was the central bank gave them a better tool to promote the safety and the soundness of our national payment system. And that's why you see everything is automated. And now you see they're moving to the sand dollar. All of that is a part of the national payment system. There's no longer movement of physical settlement between banks. And now you see the central bank is saying now that they're going to do away with checks. Because they want all the Bahamians to use the digital currency. So under Section 8 of the Act, it says that no person after the Payment System Act came into force can establish or participate in a proposed domestic payment system unless they have made an application to the central bank for approval and the central bank grants approval in writing for such proposed payment system. So that means that if any other commercial bank were to be formed today, they have to become a part of this same system that we have now. And once you become a part of it, then the central bank would give you the rules that govern the national payment system. So that's what that piece of legislation is all about. And then the act goes it further down and speaks about the finality of payments and the protection that's afforded to the banks within the system. So let me make a note of which pieces of legislation you all would like to have. Looking for a pen. The Financial Transaction Reporting Act, right?
Yes.
And the
Yes,
regulations, right?
Yes, that would be all the acts that you went over tonight. Actually,
No, I think I already sent the BTCRA, but I'll put it again. I'll put it in again. The payments. And you want the anti-terrorism?
Everything you have, please send it to us.
The Proceeds of Crime Act. Okay, and I will send you the Computer Misuse Act. And let me see, what else? You want the Central Bank Act? That one is not too relevant, but if you want it, I can send it.
That's fine.
You want that one too?
Yes, ma'am.
Okay, I can send you that, Central Bank Act.
Thank you.
And the Data Protection Act.
Right.
Okay, so that'll be 1, 2, 3, 4, 5, 6, 7, 8, 9. They may have to send them in 3 emails, okay? Because it'll probably be large.
That's no problem.
Okay, all right. So that's it for the law. So I'm gonna send these to you all so you can read it. You can look at the sections. And then when we come next week we're gonna start with the Bahamian legal system. So what we're gonna be talking about then is we've highlighted these laws that govern banking. So what we're gonna look at is where do these laws come from and how does this common law come into play with what we do here in banking. So we're gonna look at our legal system as structure, and then I'm going to explain to you how law comes about in the Bahamas. And that is critical because when you don't know the law, then it's very difficult for you to carry out your day-to-day work. You have to be aware of all the laws that govern what you do. You don't have to be an expert, but there are certain things that you should know. So I've highlighted some of the main ones here at the very beginning. And so for your homework, you can start to read these. I'll send these to you tomorrow. I'll let the office send these because I'll put them together and send them. And then beginning next week, when we do chapter 2, we're gonna talk about the process that the House of Assembly goes through to approve pieces of legislation, the whole process from the beginning to the very end. All right. Anybody have any other questions? Because I know that's a lot of legislation to think about. No one? No? Oh, that sounds good. Now, tonight was a very easy class. Like I said, as we go further down, we're going to have cases. When you look through your book, you're going to see there are some cases. They're normally done in, yes, there are cases. Who squeak cases? Is that Ellen?
No.
Yes, there are cases, and some of those cases you will have to know. I'll try not to give you too many. But some of them will explain why you do the things you do. And some of them will also explain why there are certain provisions in the contract that the customer signed. And so you learn a lot about where they came from and why they are there. All right. So next week will be chapter 2. And then after chapter 2, it'll get a little bit more difficult. So I'm telling you now, we'll start contract law. And remember, I said the purpose of why we have to go through contract law, because everything that you do in banking is based on contract law. So when you walk into a bank, you walk in to open an account. So when you open an account, you enter into a relationship. And that relationship is that account opening document. The process for opening that account is banking law. But the way in which the arrangement is laid out in banking is based on contract law. So when we go to Unit 3, we're going to talk about contract law in its pure sense. And then when we go to Unit 4, we're going to then look at banking law using customer concept, contract concept. It'll become clearer when we get there in 2 weeks. All right? That sounds good?
Yes, ma'am.
All right.
Sounds great.
I'm going to send the legislation, and for those who have the time, they can read chapter 2.
Okay.
Okay, and depends on how quickly we go. I will begin chapter 3 next week also, because chapter 3 is long. Because I need for you to really understand contract law.
Ms. Archer,
Yes.
is it possible to get the e-copy as well, please, for the textbook, so that we can follow you exactly how you're reading it?
It'll be the same. But I mean, if you want it electronically, they can send it to you electronically.
Yeah, because in the textbook, the things that you read, it's like on different pages and stuff, so it's kind of hard to follow you while you go through the content.
Oh, okay. Okay, okay, all right. I heard you. Okay, so I hope it didn't hurt your head too much.
Just a little, you know.
A little, right? Okay.
Yeah, just a tad bit.
It did very much. Yes, ma'am. Yes, ma'am.
Yeah, because there's a lot of legislation that there's a lot. It's a lot. Okay.
So, Ms. Archer, any dates for our exams?
Oh,
All that good information?
I have your for the of December. And I have your midterm set for October 25th. Mm-hmm. Midterm is October 25th and finals is December the 13th. So as we get nearer to midterm, I'll tell you which chapters are covered in your midterm. Okay?
Okay. Is there a telephone contact?
Who, for me?
Yes, ma'am.
Once you email me, I'll give it to you.
Okay.
If you have questions, you can email me, and then I will. And if you need me to explain it and talk to you, then I'll give you my number and you can call me.
Okay.
Yeah, that's not a problem.
Okay, Ms. Archer, can you let us know what your email is, please?
It's not in the link, but everybody is.
Yes.
Yes, Archer Christine at Gmail at number 1985 at Gmail. You see it?
Yes.
Yeah. Okay. So you could just email me. Or if you're not gonna make it to class, let me know. So that if it is a subject that you probably will need some assistance in, for whatever reason you can't make it, then you may say I missed this chapter, but I really need it because I don't understand it, then you'd have to send me an email so we could arrange a time to go over it. Okay,
Yes, ma'am.
all right. So let me put the pieces of legislation together so I can have them to start to send those to you all so you can start to read it. All right?
Yes, ma'am.
Okay, so have a good night.
Yes, thank
Oh.
you.
Rest well. You will get headache, but don't worry about it. It's all a part of learning banking law. Okay? All right. So good night, everyone.
Good night.
Good night. Good night.
Night.
Good night.
Good night.
Good night.